You're listening to The Conversation. If you're a Taylor Swift fan and you were listening to Amazon Music last October, you may have heard this short message.
Hey, it's Taylor Swift.
She's encouraging people to download her new album, The Life of a Showgirl. She did a similar message for Spotify.
Hey, it's Taylor.
These two phrases, hey, it's Taylor and hey, it's Taylor Swift, may feel slightly mundane, but they're now at the front line of a new legal fightback by celebrities like Swift against AI deepfakes. In April, she applied to the US Patent and Trademark Office to trademark the two phrases as registered sound marks, along with a photo of her from her recent Eras tour. You've probably seen it. She's dressed in pink knee-high boots and holding a pink guitar. AI is making it extremely easy to manipulate video and sound to create deepfakes, putting people's images and voices into context they never agreed to. And now, as celebrities wait for the criminal law to catch up, they're trying new ways to protect themselves. But if you're not a celebrity with a big legal team, what can you do? I'm Gemma Ware from The Conversation, a news and analysis platform partnering journalists with academics. Welcome to The Conversation Weekly, where experts explain how we ended up here. In this episode, how celebrities are leading the legal fight back against AI deepfakes. Graham Austin, you're a professor of law at the University of Melbourne and also chair of private law at Victoria University of Wellington. Welcome to the podcast.
Thank you very much. It's great to be here.
So, Graham, Taylor Swift, one of the most famous singers in the world, recently submitted 3 trademark applications. Talk me through, why has she done this?
Celebrities are people who are really concerned about their images and protecting their images. They make a lot of money from their images. And so the trademark applications are ways that she can further build a kind of thicket around her identity so that she can protect it further. I mean, Taylor Swift has been the victim of deepfakes, a number of them. She's been deepfaked in pornographic contexts where people have used synthetic images of her. She famously was said to have endorsed President Trump when she didn't. And one of the other ones was where a deep fake of her was used to sell cookware. So you can understand with somebody like Taylor Swift that she's concerned about these kinds of things. We don't know what a trademark is going to give her, but it will be just another thing in her legal armory, I suppose, that will help her protect her image against all sorts of uses, including deepfakes.
And are other celebrities also taking this route?
Sure. Another one who actually has the trademarks registered is Matthew McConaughey, who has registered some of his phrases from the Dazed and Confused franchise.
All right, all right, all right.
He's also registered some of his own pictures of him. Jeremy Clarkson, a British celebrity, has applied to register his face because he was also the subject of deepfakes. It's a problem that has arisen out of new technologies. So artificial intelligence enables the production of very high quality simulations of real people in a way that wasn't possible until the rise of these sophisticated AI-driven image generating and video generating and sound generating technologies. And they've got better and better. And the ability to differentiate between real and simulated images has really been challenged as a result of the quality of these technologies that allow ordinary people to produce and disseminate these simulations of real people.
So, Graham, you're an expert in all things intellectual property. Why have these celebrities decided to go down a trademark route rather than relying on, say, copyright legislation?
Copyright and trademark are very different things. So copyright protects a specific work, like a book or a movie or a song or a poem or a TV program, whereas trademarks are a branch of intellectual property law that's used to prevent confusion in the marketplace, so consumer confusion. So Taylor Swift was applying to register her trademarks for things like entertainment services and streaming services and information about celebrities. And one of the things that she might be able to use her trademark to protect against is other people setting up fake websites, for example, that are selling information about her or images about her, so that people are confused about thinking this is really endorsed by Taylor Swift when it's not endorsed by Taylor Swift.
And why trademark a particular catchphrase or photograph rather than the whole voice or the image?
That's partly to do with how trademarks work, and that you have to confine your application to something reasonably specific. There are other forms of intellectual property that can capture the whole image of a person, I suppose. And in about half the states in the United States, there are things called personality rights that protect the image, the depiction, in some states, the voice of a person. The UK doesn't have those. They're not available in Australia or New Zealand, but other Commonwealth countries do have what we call personality rights. So India is one, Canada's another one, South Africa has some personality rights protection as well. But Taylor Swift, we have very, very good intellectual property advice from her lawyers who are really trying to create a wall around her image. Also, trademarks will have a deterrent effect for people. So people, when they're thinking about how they're going to depict Taylor Swift, they'll go and look at the trademark register and see what's registered in her name.
If she succeeds in getting her trademark, how likely is that route to protect her identity?
It's not clear that the trademark in itself is going to protect her, that she'll be able to bring a trademark infringement case. And again, part of the difficulty here is that somebody like Taylor Swift can't protect her image in all contexts. There are homage sites. She might be the subject of a parody. She might be the subject of a documentary, etc. And the law treads very carefully around trademarks to ensure that people aren't using their trademarks to exercise a monopoly that they're not entitled to. But it could serve a deterrent effect, and it could provide her with some very specific protections against, for example, fake product endorsements.
Okay, so we've been talking about deepfakes and how they've been supercharged by AI technologies, but how new is this problem of people trying to pass off one image as something else?
There have been fabricated photographs from really the beginning of photographic technology. And there was a famous example in 1865, after President Lincoln died, where his head was superimposed on the body of another politician, somebody called James Calhoun. And we don't know exactly why that happened. Lincoln himself was very conscious of the importance of the image, and he sat for a number of photographs. Calhoun's body, I suppose, he cut an heroic figure. There was flowing robes. And I think after Lincoln died, there was this real hunger for images of him, depicting him in the best light possible. And one of the ironies of that story was that Lincoln's head was superimposed on somebody who was pro-slavery, whereas, of course, Lincoln was a famous abolitionist. And the photograph was doctored in a way that changed some of the language on the photograph. So in the original photograph of Calhoun, it said things like strict constitution, free trade, sovereignty of the states. And these words were changed in the Lincoln photograph to read Constitution, Union, Proclamation of Freedom. So it wasn't just the face and the body that were changed. It was the messages and some of the documents that you can see in the photograph. The term deepfake, we think it dates from around about 2017 from an anonymous blogger on Reddit who was talking about the ability to use new technologies for what's called nudification, which is the superimposition of heads of real people onto the bodies of naked people. But there had been some earlier technologies in the 1990s that had been used to make movie stars look younger, for example. And Harrison Ford is an example of this, Robin Wright. They were made to look younger using these technologies. But they were really for specialists. The movie industry had them. The computing capacity that was required to produce those images and videos, that just wasn't in the hands of ordinary people in the way that it is now. But what's happened is technology's developed, so this is so much easier.
So you talk about how the origin of the word deepfake was tied up with this idea of sexual deepfakes, people making lewd images without their consent. How is the criminal law being used to try and criminalise deepfakes around the world?
We know that the vast majority of deepfakes are used in the sexualised context. They're described as non-consensual, intimate depictions. And the criminal law has moved faster than other areas of law in this area. The United States has the Take It Down Act from 2025, which provides a set of federal criminal laws that are targeting this material.
President Trump signs the Take It Down Act. The legislation makes it a federal crime to knowingly publish or threaten to publish intimate images online without a person's consent.
Australia has these laws, United Kingdom has these laws. Sometimes the criminal law hasn't kept up with the technology, and there was a recent case from Nova Scotia in Canada a few weeks ago where a man was being prosecuted for creating non-consensual deepfakes that it seems to be of classmates, and he created these images of these women in sexual context. And the judge couldn't prosecute him because the law hadn't kept up with the technology. It applied to the dissemination of real or genuine sexual material, but did not apply to simulated sexual material. And so this is one of the movements we're seeing in the criminal law around the world, where criminal laws are being amended to ensure that they catch the distribution of non-consensual material that is simulated. And one of the advantages of criminal laws in many countries is that law enforcement agencies will be involved, but also from the victim's perspective, it's important that the victims have available to them whatever victim support is there to help them through the humiliation and the shame and the shunning that can come from the dissemination of images depicting them.
What about more general non-sexualised deepfakes? Are there any moves to criminalise that in various parts of the world? That's
a much harder area. I think it's fair to say that there isn't the same kind of consensus around non-sexual deepfakes. There are some moves in Europe which have provided for better criminal responses. But in these kinds of areas with non-sexualized deepfakes, people are turning to the civil law. So civil law is when one person sues another person or a platform or the person who's responsible for creating the deepfakes for damages or for an injunction to stop the material from being distributed. There's a law that's currently in the Senate of the United States. It's the No Fakes Act, and No Fakes stands for Nurture Originals, Foster Art, and Keep Entertainment Safe.
A new federal bill targeting unauthorized AI deepfakes has advanced through the Senate Judiciary Committee. The bipartisan No Fakes Act would give Americans near exclusive rights over AI-generated replicas of their voice and appearance.
One of the things that's innovative and interesting about the No Fakes Act is that it creates this intellectual property right in people's images to protect them against digital simulations of them. And it's not just for celebrities, it's for anybody.
Coming up, as the criminal law still catches up on deepfakes, celebrities are turning to civil law and winning. That's after this short break.
What are you going to have? Can I have 2 pieces of mullet? necklace, a piece of sea perch, and 8 whiting fillets, please, Pauline.
From a fish and chip shop in regional Queensland
I believe we are in danger of being swamped by Asians.
to the heart of Australian politics, this is the unlikely story of the country's most controversial minor party.
Are you xenophobic? Please explain.
For 30 years, One Nation and Pauline Hanson have been ridiculed, dismissed and shut out.
Gone. I don't like it. No, I don't. Never did.
Now, no one's laughing.
One Nation continuing to surge in the polls.
Dramatic surge in support for One Nation.
The fringe becomes the mainstream.
This is the story of how a party built on fear and grievance thrived, died, and rose again to upend Australian politics.
Well, I'm back.
Hanson 2.0 is the serious, strategic, experienced, battle-hardened political operator that we see in the news today.
I'm Ashlyn McGee. This is The Making of One Nation from The Conversation, and you can search for it wherever you listen to podcasts.
Welcome back. Graham, we've been talking about criminal law, but are there any celebrities having successes using civil law against deepfakes?
There have been instances in some countries, and it's all very recent, but there have been instances in some countries, India is notable, where Bollywood stars have been able to use the civil law to shut down websites and other platforms where deepfakes have been available. And there have been a number of noteworthy cases. There's one involving Anil Kapoor, another case involving a very famous movie star in India, Aishwarya Rai Bachchan. Those cases involved sexualized deepfakes, claims that they had endorsed products and services when they hadn't, general video material depicting them. There were even firms that suggested that they were on their books for inspirational speaker gigs. And they've used what are called personality rights to go after these deep fakes. So it was a complicated set of legal proceedings where they bundled together a whole lot of false depictions of these Bollywood stars.
The Delhi court has, in fact, ruled in favour of actor Aishwarya Rai Bachchan during a hearing that took place today in the High Court, stating that unauthorised use of a name stands in violation of the actor's right to privacy and of dignity.
One of the things that's interesting about the Indian case law, and again, this is all very new law that's being developed, is, well, the judges talked not just about the commercial interests of the stars, but also about their dignitary interests. In one of the cases, they also said that this is a harm against their families and friends, that these indignities were something that their families and friends should be concerned about. So we'll see how that law develops. It's inevitable that there'll be similar cases in other countries. And my hunch is that they will look to some of the statements that have been made in the Indian cases about the broader understanding of what's at stake in this area.
And were they successful once these rulings had happened at actually getting these deepfakes taken down?
We think so. The judges were very quick to provide remedies to shut down and block access to these sites. The media reports have suggested they have taken them down. And in fact, it's been reported in the Indian media that there are further actions going ahead for damages as well in these cases. So not just getting the stuff down, but also seeking monetary relief, which may serve as a deterrent in future cases. One tool that courts have used in the Indian cases and could use is to require the platforms and the internet service to shut down the access to this material. That doesn't stop it from being distributed outside of the country. So I think projecting a few years ahead, we'll probably see the development of mutual recognition of these kinds of blocking orders so that internet service providers in other countries can be required to take the same kind of action.
Some governments are trying to push forward as well with a kind of new transparency obligation on companies or creators who are using AI. How does that fit into the picture?
When you think about digital simulations, there are a number of different kinds of harm. So there's the harm to the victim, obviously, but there are also harms to the public if they don't know whether they're dealing with something real or phony. So it matters to a lot of people in a celebrity culture whether, say, Taylor Swift is actually telling us that this cookware is great cookware. And so in some countries or regions, there are emerging transparency obligations so that there has to be information provided to viewers and consumers about whether or not this is a real person or a simulation or whether or not it's been altered. The most well-developed areas within the European Union in the AI Act, and those obligations come into force shortly. But New York State, for example, has also just passed laws requiring television advertising to be accompanied by a notice if a simulation has been used.
Going back to where we started this conversation with Taylor Swift, it is just a route really, though, for big stars with big legal teams. What about regular people? If you're an ordinary person and you find that you've been deepfaked, what can you do? What practical steps can you take?
You're right that the law has traditionally responded to the commercial interests at stake. In the sexualized context, that's different. There are emerging criminal prohibitions in this area, but for ordinary people, the legal avenues are probably a bit different than from the big celebrities that have armies of intellectual property lawyers who can look after their interests. With all of these things, it's going to depend on what country you're in, what the laws say in your country, and also where the thing is distributed. So we can only talk in general terms. First thing, don't send it out again. Don't disseminate it any further. Second thing, document everything. So take the screenshots, record the video if it's video. It could be useful to record any chat that is associated with the image, because what's in the chat can help you describe the harms that it caused, because there might be evidence there about how people have changed their view of you, or they think you're ridiculous, or that kind of discussion is going to be useful for building your legal case. If it's sexualized material, many countries go straight to the law enforcement agencies, and many of them have very good platforms for information about what to do. Find out in your country who is the online safety regulator. Seek information there. And they also often have legal advice about what you should do in those kinds of contexts. So don't just sit on it, because it will disseminate virally. So the quicker that you can take action, the better. One of the things that I'd encourage people to do is, before they upload material to social media platforms and so on, just have a look at some of the terms and conditions. They're very interesting, and many of them are in plain English, so they're pretty easy to understand. Look carefully at the adaptation right. For example, when you say you're giving a license to everybody else to make an adaptation of your image, the adaptation is essentially something that invites deepfakes. So I think that the deepfakes area is an area that requires a lot of education for people to think about how they interact with media platforms.
Thank you, Graham, for helping us learn a little bit more about it. And I am also going to go away and look at my terms and conditions on the apps that I use. So thank you. Appreciate your time today.
You're very welcome. It's very nice to talk to you.
That's it for this week's episode of The Conversation Weekly. It was written and produced by me, Gemma Ware, and Mend Marawani. Sound mixing is by Michelle Macklem, and our theme music is by Nita Saal. The Conversation is a non-profit news outlet dedicated to sharing the work of academic experts with a wider audience. If you like what we do, please consider supporting us at donate.theconversation.com. Thanks for listening.
Hello, curious kids. Have you ever wondered how high a volcano can throw lava in the air? Or
Why is it that when you're in a bath, your fingers go wrinkly?
Or even...
Will scientists be able to make a new element?
Well, you're in the right place. I'm Eloise, and welcome back to Season 2 of The Conversation's Curious Kids, the podcast where an expert answers some of your most head-scratching questions. Listen to The Conversation's Curious Kids wherever you get your podcasts.